Hello everybody, welcome back from your coffee, and thank you all for coming. It's great to see such a fantastic turnout. I want to first of all acknowledge Eamon for taking time off this morning to come, because chairpersons don't often get acknowledged, but Eamon took the time out and we were really delighted to have him. But this conference was floated last summer by one only Maria Dillon from the Employment Law Association of Ireland, and she said that there was great interest in having a conference on legal rights and older people. So I want to thank Maria for giving us the nudge in that direction, and to thank the people on the Mental Health Rights Group who all worked so hard, and Charles, you all know Charles worked extremely hard to get all of the finer points of this conference together. And to thank the programme, the LLM programme, for contributing to the funding. So I'm going to make, I suppose, three broad interconnected, or address three broad interconnected issues. I'm going to look very briefly at the context for around decision making in older people. And I'm going to make some points on the proposed law, the context, the proposed law, and then I'm going to look at the important issue briefly again on deprivation of liberty, but which is really an issue that challenges us. Just not good on these high-tech things. I've turned it off. Obviously, I'm not good on them. Yeah, that sounds a good start. Just very briefly on the demographics, and they're you know, a lot of you will have seen these figures already. You know that 47,000 approximately are people diagnosed with some form of dementia, and the age figures are, 1 in 20 over 65 and 1 in 4 people over 80 has a dementia. There's also a gender element to that because of the greater longevity of women. So we need to be mindful of that factor. But it's not only people with dementia, so it's people with maybe acquired brain injury, people who may have some challenges around decision making and so on, and capacity. But I think the important point is that this legislation that we're hoping to introduce it stands to affect all of us in one way or another, either directly or indirectly, through family, friends, or ourselves. So it's really important as to how we go about our business. Decisions are made all the time for older people with little regard of what they might want. It's almost like a perception that if you present in a particular way and you have various types of factors like maybe, a disability, grey hair, maybe shy or slow in talking, not good in environments like institutions and hospitals and so on, that you're not able to assert yourself, then there are lots of assumptions made. I think the success of this law, and that means that it has to benefit people. That's the standard of the success, that it will benefit people. It will require significant attitudinal shift. So that's very important to remember, that we need to really consider what deprivation of legal capacity does to people in the way we do it now and in the informal way in which we do it. So just to say to people that the European Court of Human Rights has said on several occasions that the deprivation of legal capacity is at least equally important as the deprivation of liberty. And we have, up to today, really been very conscious of deprivation of liberty in our constitution and in lots of other areas. So we need to be mindful of the impact of a deprivation of legal capacity. So a little bit on that. What does it do to people? Well, in our own case, an Irish case of HSE and MX around capacity to consent to certain kinds of treatment for mental illness, Judge McMenamin talked about human rights and talked about the massive impact that deprivation of liberty can have. He talked about the legal and social consequences arising from that. And there's some really good research done by the Fundamental Rights Agency of the European Union, which is available online, which identified things like that people talked about passivity, learned helplessness. Suddenly you're shut out. Profound loss of self-esteem and control. So that's really, this is based on some very recent research. The lack of explanation or an opportunity to challenge it. These are the reasons why we need to change and move away from current attitudes and systems. And one of the issues that came to my mind, I was giving a seminar in a county far from here, not too far from here, and I was approached by a key worker of a woman who was recognised as having an intellectual disability, and her parents had died some time earlier. And they'd had a little business in a rural area, and she was very integrated in her community. And by the time her second parent died, people felt she would be much safer and much better by being moved into a service provider, into a safe residential care with other people. Now, her key worker was very concerned that in order to do all of that, she was made a ward of court. And she wondered, how did she get out of being a ward of court? Because she felt she didn't really lack capacity for making decisions around her own life at all. So this key worker, who was not in the upper echelons of the management system of this organisation, but was really concerned and wondered how was it possible to get out of wardship. And she felt there was a huge loss to this young woman because she lost her place in her own community and her family business. And there really wasn't much going back on that because it was all sold. And the final one I want to mention there is the cycle of disempowerment that comes with loss of legal capacity. And in some instances, we can't reverse what's a reality for people, but it's how we do it and what sort of safeguards we put into place. And the case of Stanev in Bulgaria, it's a fairly recent European Court of Human Rights case, is really instructive on this issue, because Stanev was living at home with not very close relatives, but relatives. And he was, according to all the information, he was irritating his family. And they decided he was drinking and behaving in different ways, and there was a question as whether he had a mental illness or not. And his family instigated guardianship proceedings against him, and he was taken into partial guardianship without any notice to himself, and he didn't know who his guardian was. And with that, he was sent 400 miles away into the mountains, into a social care home. And the case is important because it was the first one that identified, outside of psychiatric care, these detention, that you have to have safeguards around detention. So Stanev languished in this place. He was allowed out 3 times. He was informal, as it were, but he wasn't allowed out because he had no personal papers. So 3 times he came home in the 7 years. And he lived in conditions that the Committee for the Prevention of Torture under the European system had condemned on 3 occasions to Bulgaria and said it should be closed, where they didn't even have mattresses on beds, ice on the inside of windows, that sort of thing. So he remained there for 7 years until he managed, through his contacts and the Mental Disability Advocacy Centre, an NGO took his case up with the European Court of Human Rights, and it was established that he was deprived of his liberty improperly, illegally, and so on. And his legal capacity was at the very core of all of that he was initially deprived of his legal capacity, and the cascade of events that affected his life for the next 7 years impacted most profoundly on his life. So they're the kind of impacts from a finding of incapacity in the systems we have at the moment. So just very briefly, to look at the UN Convention on the Rights of Persons with Disabilities has come our way in the last 7 or 8 years. And Ireland has signed this convention but hasn't yet ratified it. And it has, I suppose, reignited a lot of interest, enthusiasm, and so on around human rights of people with disabilities. And the area of legal capacity is heavily emphasised, with the notion that people must be treated equally, no matter what their disability is, equal with everyone else in all aspects of life. And that instead of deciding that people don't have legal capacity, we must assist and support people to make their own decisions. That's the whole idea behind it, assistance to make decisions. And there's also provision for recognising and respecting the rights, will and preferences, but also to have appropriate and effective safeguards so that there aren't, that exploitation and all the rest of it doesn't happen either, because safeguards can also, abuse people. They may have the opposite effect to what is intended, so we have to be careful about those as well. But I just mentioned Article 19 there. It's not on the right of legal capacity, it's on the right to live in and be included in the community. And it's really important in the case of older people, where it's almost like a setting when you listen, especially in the recent debates, to leaders in the health system saying we're negotiating with nursing homes. And I'm not saying nursing homes aren't necessary in all of this, but it's the kind of number one thing. And I heard very few people say we must look into what people want and try and follow what they want, whether it is to return home, live with a relative, or enter some form of residential care. We don't have that as our first line, and we need to. But Article 19 looks like, you kind of think, oh, these conventions, what good are they? But interestingly enough, Article 19 was used recently in a case involving some children who were they were children with autism in one family. I think two children, I think. I've forgotten some of the detail. But I was just reading briefly about it, and they, in the jurisdiction, I think it was in the Czech Republic, the children were destined for residential care, institutional care. Their families did not want them to have residential care, and they went through the court system. And the Supreme Court in the Czech Republic, based on Article 19 of the UN Convention, did not send them into residential care. And that's regarded as a huge coup in that kind of jurisdiction, but also it gives us hope that this also could be used here, however we do it. So just very briefly, because sometimes it's good to have a bit of clarity on the difference between legal capacity and mental capacity. And legal capacity is just where the law recognises someone over 18, for example, can make contracts, get married, whatever it might be. And then mental capacity focuses on the person's decision-making abilities. And these can vary from time to time, from one decision to another. And if we think about ourselves, lots of factors influence how we make decisions. I mean, the perfect example is voting. Could you attach rationality sometimes to how people vote, how any of us vote? No. Social, emotional and environmental factors are very relevant, and I'm going to come back to that because they really are crucial. And we unfortunately narrow things down into little bite sizes. And if it doesn't work for the person at the receiving end, we say, oh no, that's it, over and done with, they don't have capacity. We need to be very conscious of how we do these things. So, sorry now. Okay. So I just wanted to mention that about legal capacity and mental capacity. And the environmental issues. And another thing I think is very important to remember, that often we don't realise that when someone is in a hospital setting, say even a general hospital setting, an older person, there's an immediate change of the dynamic, because and if you've ever been in a hospital bed, you know how vulnerable you are. Once you get into the bed, you think, oh, what's happening next? Do I have to say yes? No matter how assertive you are, that happens to you. So how much more is it for someone who's feeling a little bit foggy about how things are happening? And who's there batting for me, and who can I rely on, and can they just tell me what to do, and do I have to do it? Maybe yes. So these are all the things we need to consider when we're looking at environmental factors. And the power thing, one of the members of our human rights group, mental health human rights group, Dr. Liz Brosnan, has done a lot of work on this in power relationships in terms of mental health care delivery, and it's really useful stuff in terms of training and raising awareness. So I'm going to move on now after those introductory points and look at the bill itself. Now, I'm hoping not to cross over with what Patricia said, because I'm making slightly different points, and also with Sean as well, because we're all coming, I suppose, doing different bits of it. But in the long title to this bill, and I think this is important to remember, because if we're looking at why we're going to do this, the long title says that it's intended to reform the law relating to persons who require or may require assistance in exercising their decision-making capacity, whether immediately or in the future. So that's what this bill is about. Whatever else is in it, that's what it's about to start with. Assisting people in whatever way possible. That's the primary intention. That's our starting point. It may change if someone is found not to be able to make a decision with all of the efforts that are available there. But we must start at that point, that it's to assist people. And so what it does then is it proposes a range of formal supports within a framework for decision-making assistance, underpinned by a set of guiding principles, which I'll talk a little bit about. So that's the intention, and Patricia listed out the different categories there, and I've included them in this, but you can look through that in your own time. So then looking at the guiding principles, and my view of the guiding principles, and this is why I go on and on about them, is that if we don't get these right, we'll get nothing else right in the bill. We really need to actually almost absorb them, have them on the door, have them there so we know this is what we're meant to be doing. So the first thing is the presumption of capacity, and that it embraces the empowering ethos of the bill, in the principle that everyone has the right to make decisions, that presumption of capacity. It's not new in this bill, as Patricia said already. It's out there already in terms of common law and so on. And it must be our starting point. The presumption of capacity, whatever you do, you're starting at that position. Now, the House of Lords report on their own mental capacity bill, which is similar in lots of ways to ours, although we have advanced ours in a different way in terms of the assistance framework. But they found that what was happening with the presumption of capacity was that people were overly using it to either leave people alone entirely, oh, you're fine, the presumption of capacity applies to you, we don't have to do anything. And people were left without services, that it was used in another way. So we have to watch all these. These are all learning points for us. And also that it could be over-enthusiastically used and overturned more easily. They were the 2 points that seemed to come out of that. Now, and the next thing in the principles is that a person is not to be deemed unable to make a decision unless all practicable steps have been taken to help the person without success. So the idea is you must assist the person before their rights are removed in any way, in all possible ways. I'm just going to give you a little anecdote. It's a contribution that was made in England when they were having hearings like our Oireachtas hearings on their mental capacity bill. And the Queen's Counsel, Daniel Brennan, some of you might have heard of him, he was involved in a lot of cases that pertain to Northern Ireland and elsewhere. And he was a QC, and he was giving evidence before it of his experience of the arbitrariness of the removal of legal capacity, or the informal way in which people are ignored. And what he said was, he had a client who'd had a serious accident 12 years before these hearings. And the client was going through legal procedures, suing in connection with it. And he was regarded by everybody as being a zombie. That's an awful word, but that was the word Daniel Brennan used, by his family, by everybody. He was mobile, but all he could do was grunt. So he didn't use words at all, and there didn't seem to be any ability to communicate. However, he was given an interim award of damages in the settlement, and straight away he bought speech and language therapy. And he, after his second period of speech and language therapy, he was able to communicate in a fully capacitous way. So Daniel Brennan was told this about his client and didn't believe it. So he went to meet him and challenged him and asked him all kinds of questions, and he was able to answer them. And then he thought, well, I'll really challenge him now. I'll get him to spell encyclopedia, which he did just like that. And I was telling this to some of my colleagues, now the ones who aren't here, and they didn't know if they could spell encyclopedia just off the top like that. But what it points to is the arbitrariness. The fact that he got his interim award, the fact that he was able to access a good communication therapist, and so on. So these are the reasons why we have to be aware. The unwise decisions, well, I suppose I'd say here in this room, if you want to put up hands up, if there's anybody who hasn't made an unwise decision, because you are very unusual if you haven't, because that's how we learn. But if you are in another situation, there's a much heavier onus on you. If you have a diagnosis of some sort, or if you're labelled in some way, then maybe the forces upon you are much greater to actually come good on your decision making and make no mistakes. So we have to watch that, because actually it's recognised in research as the leading trigger for assessments of capacity leading to life changes, and there's lots of research on that. We're a very risk-averse society, and we need to look at what kind of risks we allow, what kind of risks we don't allow. We're very risk-averse when it comes to physical safety. We do not care so much about emotional and that area of so much importance in our lives, our emotional, our mental spaces, and so on. So, and it's all driven by, people will say, oh, but we have a duty of care, you know, this whole notion of duty of care. We need to identify the kind of risks we are prepared to take, because we can't wrap everybody in cotton wool forever, especially with numbers and especially with everything else. That's a key challenge anyway, but not even that. That's not the justification. But one of the quotes that I'll talk about a little bit later is from Judge Mumby, a very, very famous judge in England right now, who's highly expert on the area of legal capacity and people's rights, and he's well worth following in case law, as are a couple of other judges. And he said, we must identify the kinds of risks, and I have this written later just to tell you, and you'll all be able to access the papers, they're all online, they will be all online. We must identify the kinds of risks we are willing to tolerate. He said, manageable or acceptable risk, we must look at it as a price appropriately to be paid for some good. And he said, the good of the older person. So we have to get into a different kind of mindset around this. Now, the other thing about unwise decisions, the research has also found that professionals are very poor at disentangling unwise decisions from a decision that the person lacks capacity. And that's another warning one for us all. Just to reiterate what Patricia said earlier, we must understand the difference between a lack of understanding of the issues and an irrational decision, which we're all entitled to make. Okay. So, participation, these are more principles, and Patricia has looked at them, and I'm just going to go through them very briefly because I know time isn't on our side. But the intervener, the person who's involved in intervening, whoever they are, and it applies right across the board, as Patricia has said, must encourage and facilitate participation. They must also assist the person to improve their participation. So it isn't just saying, well, now, are you able to come today? Oh, no, you can't. You actually will have an obligation to ensure that the person is involved in the decision making about them, and that you help them in every way possible to be involved. And give effect again, and this has been dealt with already, the will and preferences, which is really important and reflects the UN Convention. The words are mirror that, I suppose. And we don't have best interests in this law. The decisions are not, because it was believed that it would be overly paternalistic and would allow the current systems to continue. And then consult others, and that's very wide, including healthcare professionals, but the people the person mentions, people in their lives and so on. And I'm coming to a case later on called Manuela Sykes, which is really good for learning everything about capacity, really, and how things should go, and her how they dealt with people in her life and people she was connected to. And then the interventions must be the least restrictive of rights and freedoms, and the likelihood of recovery and so on. And one has to ask that if you're first thinking with somebody who's maybe in hospital and they're waiting to go home, waiting for a support network for home, and then instead there's a big push on to move people into residential care. Is that the least restrictive situation for that person? I don't think so. And there must also be respect for the person's right to dignity and so on, these core human rights. So if you're making a decision about the destiny of someone else and you decide you're just trying to justify by saying, oh yes, we do respect the person's dignity, bodily integrity and so on, and you've done this without consent, then you're not respecting that person's dignity. Okay, and I don't want to go into the definition because Patricia has done this already, but what I want to say is that information is crucial. How you communicate to somebody, and I know Mary is going to be doing that later, in talking about having your client and so on, and how you communicate it with your client as a lawyer. But it's really very crucial, the language we use and so on. Is it a multidisciplinary team approach? And some people would say that in the past the approach has been over medicalised, too narrow to take account of the whole thing of a person's life that comes into a decision around capacity, which is really important, because remember, the result of a capacity assessment is of profound importance to that individual. It could change the whole course of that person's life. And that's why it's very, very important. One of the judges from the Court of Protection in England made this statement, which I usually hang on to in any kind of presentation I do, because I think it's really good for making us think. And she said, consider the implications of taking a test where you are judged by standards you know nothing about. You've no idea what are or are not the right answers. And the result of not passing means control over your destiny and affairs are taken from you. So it's a somewhat measure of what it might be like. So with all of this, I'm almost finished on this part now. And I just would say that from now on, you can't be going around saying, does he or she have mental capacity? That broad brush approach of the past is going. In fact, it should be gone now, as Patricia rightly says. It's about a specific decision at a particular time, but it's also crucially about assisting the person to make that decision. Now, and I mentioned already, the assessor's role is crucial, particularly relevant to certain categories of professionals, in England at least, and anything that inhibits communication needs to be identified. Cultural differences, how are we good on that? Are we good at communicating with people from culturally different backgrounds, whatever they might be? Personal preferences. What about the environment in which someone is assessed? In Australia, in some jurisdictions, they will not allow a person to be assessed in an alien environment like a hospital ward, where they clearly don't live, but rather in the place they call home, the place the person is most comfortable in. So that's really important, and I've mentioned information being crucial already to all of that. Now there's I've a reference there to Charlotte Emmett's research, which is excellent. It's called Homeward Bound or Bound for Home, and the title itself is super, because it relates to research, a small-scale research, but really excellent, carried out on older people who went into general hospital wards, and what happened to them, and whether the law was applied properly or not. And this is just very briefly on that there was huge, where there was disagreement on care and protection between the individual and the staff. That was the leading trigger, and I've said that already, for a formal assessment. But what they found was that legal standards applying to the assessment of capacity are not routinely applied in hospital settings when assessing the person's capacity to decide on where she should live on discharge. And that professionals profess to be familiar with the law, but clearly from her research they were not applying it, and they didn't understand. What was really shocking altogether was, and maybe this doesn't come as news to some of you, that whether you were trained or not didn't matter. That the people who received no training were no worse than the people who had received training. And that points to something about how we do training. Our training systems, we need to look at all of that if this is to work. And then I've said it already about separating unwise decisions. But one of the most important things, and it's current now in our current crisis in healthcare, is that you need much greater legal scrutiny of decisions to change someone's residence from their own home to somewhere else where the hospital is in between making those decisions, or whatever might be in between. That you need advocacy, you need some extra measures to attach to that. Because remember, you're changing the course of someone's life. There was a case in England last week of a 90-year-old man who was being financially exploited, or his friends were worried that he lived on his own. And he had wandered out of his house, maybe in a slight state of undress, nothing very serious. And the law was used, the mental capacity law was used in England, and he was against his will, brought to a residential centre, nursing home care. And it took 7 months for him to get out with the help of his friends. And otherwise, if the friends hadn't acted, he might be still there. And that was going to be his destiny against his will, using the law in an improper way because he was being financially exploited. Is that the answer? It wasn't his problem. It was somebody else who was exploiting him. So they would just simply, presumably, move on to some other person. Now I'm going to look at the cases, and then I'm almost finished then. So we look at a couple of English cases which I think are critical on this area of capacity and residence. And the first one is CC and KK. And CC and KK is a very interesting case of a woman who was widowed and moved from her original home to rent a house in a particular area of the UK. And she had a lot of physical needs. She needed daily different kinds of supports at home. She used a wheelchair at times. She needed a hoist sometimes, depending on her condition. And the facts of the matter were she had actually had a period in a nursing home and wanted to come home and came home. But then following a critical incident, and the critical incident was a cumulative incident, I suppose, really, if that's not a contradiction. She began phoning Lifeline services. She had an alarm button, which is not uncommon now. And she began phoning this service. And between January and June, she phoned it over 1,000 times. And so it triggered concern. And so the social workers assessed her and said she lacks capacity to decide on her place of residence. That was the issue being decided on. So she was moved into a residential place and was not happy there. And she challenged it. And she was one of the first reported cases where she herself, as a personal litigant, and this is unusual, went into the Court of Protection and spoke for herself. And that's another point. Not to take this as the kind of case that's going to happen. She was articulate. Not everybody in that situation is articulate, and we have to remember that as well. But there was huge opposition to her return home. She was opposed by 2 doctors and the social workers. And one person stood by her side all the time in the system, and presumably that's all you need, hopefully. You'll always have one person to stand by you in these situations. And the judge was really interesting in this case, Judge Baker. He questioned every bit of the assessments that were done, the medical assessments, the social work assessments. He threw out one doctor's assessment completely. It was loosely based on mini-mental state examination, which really shouldn't happen now as something that decides on your destiny or anybody else's. The judge, felt that she had capacity to decide on her residence. He said she showed none of the signs of dementia that he'd been told about, or few of those signs of dementia. What she said was, and it echoes something that was said earlier, if I fall over and die on the floor, I die on the floor. And there probably isn't anybody in this room who hasn't heard somebody say that. I'd like to die in my own home, in my own bed, whatever. And even if I fall, yes. But we must first look at why you might fall, and be sensible rather than rushing to the most extreme conclusion. She was able to bear the risk. It's other people who can't bear the risk. Family want their members to be safe. They want to feel Mammy is safe, Mammy won't fall, and so on. And that's understandable too. So we have to look at how we reduce risks to people, like the risk of exploitation. It isn't to remove the person from their life to satisfy something else that's going on. And I say, what about the emotional risk? And that came up in this case and in the last one I'm going to mention. In KK, Judge, and I won't go through all the quotes, but I think some of them are really important, Judge Baker's quotes. A disabled person and a person with a degenerative condition is as entitled as anyone else to the protection of the presumption of capacity. And that's where the presumption of capacity is critically important. Professionals and court must not be unduly influenced by the protection imperative. And that's right through our system at the moment. We think we're protecting people, but what are we really doing to their heads and their hearts and so on? And he also said there's a risk that all professionals, and he was modest enough to say, including a judge in the Court of Protection, may feel drawn towards an outcome that's more protective of the adult and thus in certain circumstances, in that situation, fail to carry out an objective assessment of capacity. Overwhelmed by external factors, by lack of services, that actually colours everything. And then the court said, obviously, you have to be careful. But, and I'm sure you'll agree with these kind of statements, the fact is that all life involves risk, and the young, elderly and vulnerable are exposed to additional risks, and to risks they are maybe less well equipped to cope with. But physical health and safety can sometimes be bought at a too high a price. So these are the things. Now, this is the quote I really want you, if you remember nothing from this, and remember this quote, because I think this quote would make a difference. Judge Mumby on acceptable risk. He said, the emphasis must be on sensible risk appraisal, not striving to avoid all risk, whatever the price, but instead seeking a proper balance and being willing to tolerate manageable or acceptable risks as the price appropriately to be paid in order to achieve some other good, in the good of the elderly or vulnerable person's happiness. What good is it making someone safer if it merely makes them miserable? So that's his very important quote. Now, I'm coming to the last bit, and I have 4 slides. I'll run. I don't want to be waving power. Okay, the European Convention on Human Rights, deprivation of liberty. This is my last piece. Article 5 deals with deprivation of liberty. So if you're going to deprive someone of their liberty, you must have proper procedures and safeguards. And we must also be aware that sometimes safeguards can actually be abusive to people as well. We looked very quickly at the English situation, just 1 sentence on it. What is detention? Well, just to give you 2 cases where they talked about the kind of detention, what it means, where there's complete and effective control by staff over medication, supervision, assessment, treatment, care, residence and movements. And that was in HL in the UK, the case concerning the autistic man who was moved into a psychiatric hospital as an informal patient, but not allowed to leave. His family weren't allowed to see him. So as a result of that case, the changes in the capacity law have arisen. The Stork in Germany case then advanced that a little bit more, and they talked about the objective element. There are 2 elements, objective and subjective, in deciding whether someone is deprived of their liberty. Confined in a space for a period of time, what they say is not negligible period of time. And the subjective element is the person hasn't consented. So if those 2 are present, the European Court of Human Rights have said that they are deprived of their liberty. Therefore, you must have procedures and safeguards in place. We have none of those in place right now with all of the people who are living in all kinds of residential centres, nursing homes and so on. And there's no proposal in our, well, as we know already, in our proposed capacity legislation to do anything about this. But we must be careful, because in England they introduced deprivation of liberty safeguards, which have weighed very heavily on the system. And one would have to question whether these safeguards have actually benefited the individuals at the receiving end in the way that really was intended. And it looks like not is the answer to that. Because just last year, a decision was made around a new higher standard in the community, that people can be deprived of their liberty while living in community residences and so on. And since then, there has been a massive rush on the Court of Protection to authorise, because they have a system in their capacity law to authorise deprivations of liberty. So it was estimated by the end of last year, the cases happened around April or May, so by the end of last year they anticipated that there'd be a further 50,000 authorisations of deprivation of liberty. Now you might say, oh, that's great, the safeguards are in place. What are we doing? Somebody described it as the great confinement, that we're now gone into authorising the deprivation of liberty of people who lack capacity. On the other hand, we're trying to change laws on mental health where we don't deprive people quite so much of their liberty and move away from all of that. So we have it backways if we go down this route. And I think that's really, really an issue we need to consider when we're shouting about deprivation of liberty. I think we have to apply our minds much more to what we really want. What is it we're trying to achieve? As Mervyn said, what is the question? and how will it achieve good, rather than jumping into something that, is on hiding to nothing. So, when a person is deprived of their liberty, you can use Article 5. What we've really overlooked is Article 8 of the European Convention on Human Rights, which talks about respect for the privacy, family, home life of the person. And in a recent case, and I don't want to go into it, Article 8 can be used to actually address whether or not a person should be moved from their own home. Because in the Hillingdon and Neary case, and some of you might have come across Neary, he was the young autistic man who lived with his father. He was moved for respite into residential care and not allowed out. And his father had to fight to get him out. And the court said in that case, sorry, I should have changed it on. And I'll come back to that now in a moment. The issue that arises under Article 8 represents the nub of the matter. The principles surrounding the right to respect for family life are well understood. They apply directly to cases where the legitimacy of removal of a person from a family is in question. And he said it shouldn't be confused with Article 5. Article 5 is after the fact. This is much more positive. We could use Article 8 much more usefully to address whether or not a person should be moved. So I'll skip most of that, Eamon, because I'm very conscious. Judge Mumby again, and going back to him, I'm his biggest fan at the moment. Compliance or consent. We needn't fool ourselves about this issue. Again, it comes back to several other issues around power and so on. One cannot conflate the absence of objection with consent, he says, and the European Court of Human Rights has said this as well. And to equate helpless acquiescence with consent when a person is confronted with the misuse or misrepresentation of non-existent authority by an agent of the state is both unprincipled and indeed fraught with potential danger. He said submission in the face of asserted state authority is not the same as consent. So finally, I'm going to talk about Manuela Sykes. And this is the case I'd say to all of you, read it. It is a fantastic case. And the judge in it, Anselm Eldergill, has spoken in Ireland. Some of you probably know him. He's wonderful. We're delighted about him being a judge in England. He's leading the way for us. So Manuela was 89, had lived 60 years in the borough of Westminster all her life. She was a campaigner for human rights, for the rights of people with dementia. And in 2006, she was diagnosed with dementia herself. She made what Patricia was talking about, a lasting power of attorney. She made an advanced care directive. And in her lasting power of attorney, she said, I want to live in my own home as long as possible. So circumstances caught up on her and she became very ill and appeared to be neglecting her health, wouldn't allow carers in and so on, and had lots of rows with people, wandering and all the rest of it. And she ended up being taken under the Mental Health Act into nursing home care. The situation there allows that to happen. So she was living properly under the law, deprived of her legal capacity, deprived of her liberty, all authorised under the law. Her personal representative, a long-time family friend, again it's really important, she didn't have immediate children or an immediate spouse or partner in her life. So this person stepped in and realised how unhappy she was in the nursing home. She was really, really unhappy. And he said, can we have a trial at home for her? This is what she would like. This is clearly why she's reacting in the nursing home so badly. And the issue of trial came up, and Anselm Eldergill said, if not now, when? Because she was 89. He said, her life is drawing to a close. It's her life. Several last months of freedom in one's own home at the end of one's life is worth having for many periods, people with serious progressive illnesses, even if it comes at a cost of some distress. And what was interesting there was, and that was something that struck me, that Mervyn said as well, about that circle. She had two nieces and she had her friend, and along with them and the care provided by the local authority, they were able to provide her with enough care to allow her to go home. And I'll skip over this, and this is my last slide, and I'm really sorry for going over time. Judge Eldergill said, it's her welfare in the context of her wishes, feelings, beliefs and values. And that's where, again, to emphasise beliefs and values. That is important. This is the principle of beneficence, which asserts an obligation to help others further their important and legitimate interests. In this important sense, Judge Eldergill said, the judge, no less than the local authority, is her servant, not her master. So he prioritised her emotional welfare, and that's the critical point. We're always prioritising, well, I shouldn't say always, because that's absolute, but we do a lot of prioritising physical welfare over emotional welfare. And in this, he did the opposite. And I thought that is such an encouraging, positive decision. So that's it. And thanks for your attention. Sorry for going over time.